Mr. Redden, have you been given a copy of the criminal complaint this morning?
Yes, I have been given one.
You're being charged with count 1, attempt murder, victim 60 years of age or older, a felony. Count 2, battery on a protected person resulting in substantial bodily harm, victim 60 years of age or older, a felony. Count 3, extortion by threat, a felony. Count 4, intimidating a public officer, a felony. Count 5, 6, 7, 8, and 9 are all battery on an officer, the same name victim. Oh, and by the way, I do not know any of the other victims named in the criminal complaint. Those are all felony offenses. Count 10, performance of act or neglect of duty and willful or wanton disregard of safety or persons of property resulting in substantial bodily harm or death, a felony. Battery on a protected person, count 11, that's a gross misdemeanor offense. Count 12, battery by a prisoner, a felony. Count 13, unlawful act related to human excrement or bodily fluid, a felony. All allegedly occurring on January 3rd of 2024. Do you understand these charges?
Yes, I understand.
Can you afford to hire a private lawyer at this time? I'm sorry?
I'm trying to,
Can you afford to hire a private lawyer of your own expense and choosing?
no, not at this time, no.
Are you a veteran or a member of our military?
No.
I can appoint a lawyer from the Public Defender's Office to represent you.
Thank you, Your Honor. He's going to also waive the 15 days that and will do 30 days.
Okay. Sir, you have a right to a preliminary hearing within 15 days, and Ms. Medina has said that she's talked with you about that, and you're willing to give up that 15-day period and instead set your preliminary hearing within about 30 days. Is that okay?
Yes, that's fine.
Is this okay with the state?
Yes, Your Honor.
Okay. Does the state, yes?
After we get the date, can we approach?
Sure. Is there anything else, Ms. Mercer, you want to address?
No, Your Honor.
Okay. All right. Here's a 30-day preliminary hearing date, unless I see you earlier, and if you'd like to approach, you may.
February 14th.
Wow. So I am completely shocked. I know that I was expecting him to get, the battery charges, but attempted murder. Let's go review that. So he is being charged with attempted murder against an older person. I wonder if the judge, how she feels about being classified as an older person. Battery on a protected person resulting in substantial bodily harm. Extortion, intimidating public officer with the threat of force, disregarding safety of a person resulting in substantial bodily harm, battery by a probationer or parolee, unlawful act regarding fluid. This is when he spit on them, and then battery on a protected person's 6 counts. 1, 2, 3, 4, 5, 6, 7, 8, and then 5. Wow. So I mean, what is fascinating about this from my perspective, and then let's go over here about how why I think they're going to be able to pull off the attempted murder charge is, so what's fascinating is that I just assumed they were going to go straight up with the battery charges, because just the battery charges alone under the legislation is 30 years, 6 months run consecutively. And they're going for the whole caboodle. They want to send him away for life. What's interesting about this to me is that he has nothing to lose. He's going to have to go to court. He's going to have to go to trial on this. And trial, as you saw, was set for, at least preliminary, was set for February 14th, 9:30 a.m. Not trial itself, but the preliminary. And I do, I wonder if they're going to offer some type of plea deal, or if they want to see this through. They're going to say, no, we're going to trial. We're putting you away for attempted murder. And what's interesting again about this is, before you do the attempted murder charge, it's all on camera, right? There's no doubt that it was battery. You could send them away for 30 years, 6 months. But when you go to a jury trial on attempted murder, you can now create a defense where maybe you think it wasn't attempted murder. He was angry. He wanted to. But here's something that he said immediately after he attacked the judge, where he incriminated himself, which might be part or a big part of the case. And let's just go over that real quick.
At the Clark County Detention Center, Redden reportedly spat in the face of a corrections officer. While he was being strip searched, corrections officers heard him utter the words, "He had a bad day," and tried to kill the judge today.
Well, maybe you got me a blast from the past over there, but there it is. That's what he said on the record. And, who knows if this goes to trial, maybe that's going to come back to bite him, as if you needed it, though, right? You do have on video camera him attacking the judge. And I don't know if you saw this footage yet. So I'm going to play it for you just in case you haven't. I know many haven't yet seen it. This is a view that many haven't seen, and it was like a new angle. You can see it here where the judge is giving it that initial sentence, and he really gets just a step and a half in front of the bailiff. And we'll play it on slow motion for you now. Right here, we'll do it. We'll put it on slow motion. You can see the bailiff going behind him, and he looks. And he makes a choice. I'm going to attack the judge. He jumps over that table. And then as we all saw, the Superman jump to go and get the judge. And, I guess right now we can do a little bit of observation of what we saw here. There was some differences, of course, in this hearing than there was in the previous one. He doesn't have a spit mask, but he does have, it looks like, even more from the sheriff's department surrounding him. And Redden's a big guy. He's, I think, 6'2", and they all look a few inches taller. So they got their biggest of the group to stand there again as a show of force. And still has the gloves on and all the cuffs. And this is, it was quite interesting also, as the judge stated, she had to, her daughter is on her, that Kennedy's is on her track, but that there's no reason that she should recuse herself. She gave those reasons, that she is friends with the other judge, that, as we can see, is not being involved in this specific case, but that she doesn't have a cell phone number, that, and it does leave, if he does go to trial and he is found guilty, it does leave it open for appeal, of course, that she should have recused herself, but I think it's unlikely he'd win that appeal unless they can prove something. But we'll keep you posted on this case. Thank you, Richard, again for the help in setting this up. And with that, I'll let you go.